Good morning, everyone. Thank you for joining and welcome to this Inside Hub session. We will speak today about remediation, reparation, and rebuilding trust after a human rights crisis, or better, what you have to do facing out a crisis and restarting all over again. My name is Paulina Hagengruber. I am the Director of Strategy and Business Development at Learning, and I have the pleasure of being your host today. I am a fully qualified lawyer, and I advise clients at Learning in the fields of public affairs and crisis communications. These topics have shaped my professional life for 20 years now. A quick intro to those who don't know us yet. Learning is an international management consultancy based in Berlin. We are specialized in business and human rights. We advise companies on all aspects of human rights and environmental due diligence. This includes also cases of human rights crisis. During this session today, we will have a look on remediation, reparation, and rebuilding trust facing out a human rights crisis. Crises are a broad and multi-layered topic. Our focus area will be on the second half of crisis. The crucial parts of crisis prevention, how to prepare for and how to respond to crisis were the topics of our first webinar on April 29th. But don't be afraid, you don't have to have the knowledge of the first webinar to follow this webinar. We will send the link to both webinars in our after webinar communication. I am here today with two of my colleagues. They are experts in crisis and access to justice. Leonel Lisboa is a consultant at Learning and the head of Learning Academy. He advises companies in how to build the suitable capacities. He leads trainings and human rights crisis simulations. Leonel is an experienced Brazilian lawyer. He has been working for more than a decade in the field of business and human rights. Leonel played a pivotal role in the emergency response to the 2019 Brumadinho Dam collapse disaster. There, he was contributing to the design of reparation measures. Mariana Izende is a consultant at Learning and an expert on grievance mechanisms and access to justice. She supports clients in setting up grievance mechanisms for effectual access to justice, and she advises clients on effective courses of action. Mariana is a lawyer. She has been working for 5 years in the field of business and human rights. Before joining Learning, Mariana worked in Brazil as a case handler. There, she was involved in a reparations program for those affected by a mining dam break with international repercussions. Thank you both for joining today. Before we start, let me remind us of a few technical things. Our Inside Hub sessions are structured as 45-minute webinars. We'll begin with a 30 minutes conversation on the topic, and the last 15 minutes will be dedicated to the Q&A session. Please use the Zoom Q&A function for your questions, not to be confused with the chat function. You can also upvote existing questions. This helps us to prioritize those questions most relevant to you. A recording of the webinar will be available for you afterwards. We will send it with the after webinar communications and the link to the first webinar. We will add also a short survey with 5 questions, and we would be happy if you could answer them. Today, we want to focus on remediation, reparation, and the rebuilding of trust facing out a human rights crisis. Let me give you an example what we mean by the term human rights crisis. If you think of the truck driver strike in Gräfenhausen, where truck drivers especially went on strike because they did not get paid at all or not the amount promised. This is a case that was very public, and it happened on our doorstep. Affected were not only the truck drivers and the logistic companies, but the brands that were supported. So also indirect effects of human rights crises can be very hard to manage for companies. Or if you think of the news on child labor in the cocoa supply chain last year, where large brands were in the spotlight. Our conclusion is a human rights crisis can hit anywhere and anytime. Crises or their further effects can often last longer than expected. So it is important that companies not only focus on the immediate crisis response, but also on how to handle the crisis on the longer run. Now I hand over to Lionel, who will guide you through the 3 phases of a crisis and focuses on the 3rd step that is in the center of our webinar today.
Thank you, Paulina, and thank you to those who are watching us now or in the recorded version. Good morning, good afternoon, good evening. So as Paulina referenced, in the previous webinar, we talked about the 3 steps of how to deal with a crisis. The first step is to prevent and prepare. The second is to respond when a crisis happens. And then the third, our focus today, is to remediate, repair, and rebuild. So just a quick refresh. In the first step, prevent and prepare, as we covered, the prevention and preparation is very connected with a robust due diligence process, the establishment of a good crisis plan, and a good baseline of trust via stakeholder engagement with internal and external stakeholders. The second step, when a crisis happens, is to respond. And businesses must focus immediately in avoiding or stopping imminent harm to human life and dignity, and also in protecting the company and preserving evidence. After this immediate phase, on a short-term basis, the company then switches or adds on this the work on a full investigation of the situation, on keeping the operations viable, on conducting strategic communication with internal and external stakeholders, and setting up the remediation framework. And this remediation framework is our focus today. So when companies move into this phase of remediating the negative impact on human rights, since we're talking about human rights crisis, so the impact on human rights, a very good initial basis for it is to go back to the very famous due diligence cycle of the OECD due diligence guidance on responsible business conduct. And the 6th step in the due diligence cycle is exactly to provide the remediation for the impacts that were caused by the business, and to collaborate with the remediation efforts when the impact was not directly caused by the company, but it contributed to that impact. So zooming in on the guidance of the OECD, if we look at section 2, items 6.1 and 6.2, we see that the guidance points to, for businesses to use the existing standards, domestic and international, for that remediation, to going back to its own precedents, domestic, particular to the company, but also domestic and international, and in coordination with the stakeholders to understand stakeholders' preferences. You see that the focus has always to be on the people that were affected, on the people that were impacted or that had their rights violated. This is the center. And this is also reflected in the United Nations guiding principles on business and human rights. On the 3 pillars structure, the 3rd pillar is the right of victims to the remediation of those human rights impacts or human rights violations. So Already in the United Nations Guiding Principles on Business and Human Rights, Principle 25 details a little bit the forms of remediation, but it is only on the commentaries of that principle. And we recommend the use of the best standard for choosing in a menu of the measures that can be done for the remediation for companies, to take a look in the resolution of the General Assembly 60-147 of 2005. This resolution carries the UN principles on basic principles and guidelines on the right to remedy and reparation for victims. It's a very interesting, very well established document. And in principle 11 of that resolution, we have a good definition, a sound and internationally accepted definition of the concept of remediation. So remediation is composed of three elements: the equal and effective access to justice, adequate, effective, and prompt reparation of the harm, and the access to relevant information. These are the three things that we are covering in this webinar today. But getting more specific and focusing on the possibilities, the options that businesses have when they face the necessity to remediate and to repair a specific harm, this resolution of the principles of the United Nations carries 5 groups of measures for reparation. So we're going to zoom in and explain all these five groups of measures. They are restitution, compensation, rehabilitation, satisfaction, and guarantees of non-repetition. So principle 19 explains restitution. And restitution has to be the priority in any process of reparation. It is to return the things as they were before. Not always possible. Unfortunately, the reality of the situation sometimes is that it's not possible to return to things as they were before. In some situations, it is. So in the example of payment deductions or payment retention of workers, the way to return to the situation as it was before the human rights impact is to make the effective payment that was retained, that was deducted. So that is a good example of restitution. The second group of measures is compensation, principle 20. Compensation comes from Latin, copesare, which is to put another weight to create a new equilibrium. So you have one impact, and then you have another weight, another measure that comes to create a new equilibrium, a new balance for the victims, for the people that were impacted. This is to compensate for physical and also mental harm, lost opportunities, loss of profit, material damage, and also moral damage. So again, in this example of retention of payment for workers, so the restitution is to pay what should be paid. The compensation would be then the payment of interest over this money that was retained, but also compensating for other things that happened because those people that had the money retained, those workers, could not use that money for something else. So all those needs that were not met, and they can have been problematic. So then you have to compensate also for that. It can be material, it can be moral damage. It can be the costs of fighting a legal battle to get the money back. Rehabilitation, principle 21, is another step. So we are going here with the steps of reality. Restitution is to return things as it was, if possible. If there is something that cannot be returned to how it was, then you compensate. But there are things that cannot be returned to how they were and cannot be compensated for. Of course, if you have, for example, the loss of life, if you have a fatality, you cannot compensate fully for the loss of life. So of course, there needs to be payment of moral damages to the families of the victim, of the fatal victim, but that's not enough. That does not restore. So the rehabilitation is the process that people that were affected can develop a capacity, an ability to deal with what cannot be compensated, what cannot be paid for. It's how to deal with the impact that remains. Sometimes you have an amputation that happens because of an accident in a company. Of course, you need restitution if possible. Restitution is not possible, so you need compensation, but you also need the rehabilitation. That person needs to learn how to live now that the body has been changed. The fourth group of measures is satisfaction. Satisfaction focuses on the ability for the people that were impacted to turn the page towards the future. So it's focused more on elements that are focused on justice and also some symbolic elements. So it is to completely stop those violations if they are still ongoing, is to get a full investigation, the verification of the facts, and the disclosure of the truth. Also to search for the disappeared or for bodily remains, if it is the case, is to have a judicial decision on the matter, is to have judicial or administrative punishment for those that are liable for that violation. And also public apologies, where the company, the business that created a situation that caused human rights impacts can publicly address those that were affected. Also the memory for the victims and trainings and education so that that fact doesn't fall into oblivion, so that we can remember that that thing actually happened. And the next one, the fifth group of measures, is the guarantees of non-repetition. Very, very important. Principle 23 is to incorporate the learnings from what happened, and so that it never happens again. So it's to incorporate in the life of the company, in history, in science, in best practices of technology, sometimes in legal framework, in sector regulations, so that that thing doesn't happen again. When companies need then to deal with reparation in this sense, sometimes you're going to have different scales of impact. If you have a very large scale, companies need a specific reparation division sometimes to deal with that. If you have a smaller impact, the framework of the activities of the company generally is able to absorb those functions. But if you have a large impact, generally you have a specific division to deal with those measures. Back to you, Paulina.
Thank you, Leonel, for explaining these 5 very important steps. Now, Mariana, could you give us an outline on the key aspects of access to remedy?
Of course. Thank you, Paulina. Thank you, Leonel. And thank you, everyone, for joining us. So as Leonel already mentioned, access to remedy is not only a step in human rights due diligence, but rather a foundational pillar of the field of the UNGPs. So let's take a step back into what access to remedy means. The UNGPs, they structure access to remedy around both procedural and substantive elements. On the substantive side, the remedies are then, as Leonel already explained, that those that seek to counteract the harm that has occurred, but also on the procedural side, there's also the requirement that the processes through which you could access the substantive solutions is fair, is impartial, is accessible also to all those that have been affected. And it's very important to keep this wide scope of possible measures in mind when you're talking about remediation, because it happens quite often in conversations with companies that this question emerges: what is remedy? What does it look like in concrete terms? We see a lot of companies focusing on internal measures, disciplinary measures. So like suspending a worker that might have been involved in a certain harm. But it's also very important to address how you're meeting the needs of the rights holders here. So how the rights holder was affected. And remember that the appropriate remediation is one that answers to the needs of those affected. So that can also mean measures that are external looking. And what are some of the ways that those affected can find remediation? Let's discuss a bit the remediation ecosystem. When we talk about access to remedy in the context of the UNGPs, it's very important to understand that no single mechanism or institution can address the full range of grievances that may arise from all business-related human rights harms. There's no expectation that one single pathway is going to be enough for all the possibilities. So we need to think in terms of a remediation ecosystem. So a network of pathways, different doors through which affected individuals and communities can seek remediation. At the foundation of this ecosystem, we have state-based grievance mechanisms, and they can be both judicial, non-judicial. Some examples are courts themselves, of course, but also national human rights institutions, sometimes labor tribunals or ombuds offices, which then form the backbone of access to justice. It is, however, important to highlight that in many parts of the world where multinational companies are active, these systems are often inaccessible, ineffective, or compromised. And that's why, in the spirit of facilitation of access to justice, particularly in transnational, extraterritorial cases, there comes the need and the possibility of using non-state-based mechanisms such as operational level grievance mechanisms, which is a concern of the UNGPs to really think of different ways and to cover all the possibilities through which affected people can reach remedy. These grievance mechanisms that are operated by companies or multi-stakeholders, they are essential for providing early stage recourse, especially to communities, workers that can be affected by business operations throughout the world. And they have a twofold role. So the first one is the early identification of adverse impacts, which gives people a channel to raise concerns and supports companies in detecting emerging risks and patterns, which contributes to a more responsible, informed human rights due diligence. So there's also this side for companies. And also allows then companies to address grievances directly and promptly before harm escalates and becomes systemic. And this can work to prevent violations to become deeper or systemic and reduce the likelihood of conflict or reputational damage. I think it's important also to highlight and to keep in mind that grievances that are treated in a grievance mechanism, it's not required that this complaint be legally recognized as a full-blown human rights abuse. These grievances, like this structure, they are designed to capture legitimate concerns, even those that are based on unfairness, broken promises to those affected, to surrounding communities, or local custom, for example. Problems, situations that, if left unaddressed, can evolve into more serious disputes. And there are, of course, questions about the effectiveness of operational grievance mechanisms. Research shows varying levels of satisfaction and success. depending on factors such as the design of the mechanism itself, but also the type and complexity of the grievances, because some issues are relatively straightforward to address, while others involve complex, multi-layered problems that challenge even the well-designed systems. And with this in consideration, I want to enter the last topic for my presentation, which is how the frameworks of grievance mechanisms can be relevant for remediation and responses to crisis. Let's remember that the UNGPs, they define grievance mechanisms as any routinized process through which grievances concern business-related human rights abuses can be raised and remedy can be sought. So one routinized process and remedy can be sought. So even if your grievance mechanism at company level might not be the primary channel through which you learn about a crisis, the framework of a grievance mechanism, this routinized process, when already established, can provide crucial support in crisis situations by, one, offering a structured approach to address urgent human rights concerns, providing these established processes that can be rapidly deployed when you already have internal knowledge on how to respond to such situations, and also ensure that affected individuals can have clear pathways to seek remedy. They know what they can, there's clarity on what they can expect and what is the process. And I would even highlight that when you're leading with crisis, there are some facilitators in terms of thinking about the remediation strategy. Because when you're designing a grievance mechanism in the normal circumstances, it's more challenging to cover all the potential reparation scenarios in advance. While when you're leading with something that has already happened, the harm has already taken place, you can develop a framework for remedy that it's more actionable, that is more concrete, that can respond directly to the harms that have already been identified. And I wanted to highlight shortly my experience working as a case handler in Brazil. It was not, the response to this dam break was not given through the company's pre-established grievance mechanism, but this knowledge was there previous to the dam break. But the reparation program that was negotiated with state representatives was built taking in consideration the effectiveness criteria of the UNGP. So the process, the spirit of this routinized process that provides stability, transparency for those affected, was then used to build this response, which needs to be a really large scope. So in short, when you're applying grievance mechanisms frameworks for dealing with crisis, for remedying crisis, it's important to keep these basic principles and structures of a grievance mechanism, what it represents, which has the primary goal of providing effective remedy to those affected, but also adjust the processes to meet the urgency and specific needs of these crisis situations. Thank you. Back to you, Paulina.
Thank you, Mariana. Let me remind all of you that you can ask your questions in the Q&A function. And I know these topics are very dense and complex, so I think there might be questions. So please. Before we go to them, let's have a short view on key aspects of communications and rebuilding trust in facing out of a human rights crisis. First of all, these crises are often longer than expected. When a crisis hits, the people are alert, they try to find solutions and communicate them as soon as possible. But it takes time to know the facts, it takes time to set up new processes. Crises are no clear continuous phase with a clear playbook. Crises can come up, go down, come up again and again. And in most cases, you can't say if the crisis is over or when. Especially from a reputational view, they stick to the brand. So does this mean that you can't do anything in this challenging situation? What can be done to rebuild trust and to regain reputation? First of all, for communications, it's important that on the long run, you need actions. proof points for the fact that you take the situation seriously and want to change it. Words are not enough. For communications in a human rights crisis, these three pillars are key: truth, consistency, and empathy. Truth. On the long run, it is more difficult to stick to the truth than one might expect. You need time to get the facts. At the same time, new allegations can come up. You have to be transparent, not only about what you know and don't know. On the long run, and especially for rebuilding trust and reputation, you need actions that show that you take this situation seriously. But you also need to be very clear on what is not possible, doable, and why. And when you have to communicate that, then it has to be truthfully and transparent. So at the beginning, you can say, we take the situation very seriously. We are sorry, but we can't comment any further at this stage as we are gathering the facts. But this does not last very long. It can be the second day that you have to communicate, we did already this and that. We are planning to do this and that, and we are still working on. Truth needs, on the long run, action, not only words. Consistency is strongly connected to truth. Stick to your message and repeat it. Trust and reputation are not rebuilt with one press statement. But the people need consistency. This means over time, they need information on where the company stands on its plan. And so again, it needs an action plan and real action to communicate this also. People responsible in companies always hope that the others, the people outside the company, are already happy when the action plan is set up and communicated. Then they want to work on it in private, but it does not work like that. You have to engage regularly with the people whose trust you lost. So you need a communications plan, background talk with media, people directly engaging with rights holders, town hall meetings with your own employees. And not only when the crisis is coming up again and again, but regularly. Empathy is maybe the most important thing. When our human rights crisis hits, there are in most cases terrible effects on human beings. Empathy is the ability to understand and share the feelings of another person. When I talk about this point, company representatives often say, yeah, this sounds nice, but we can't do that for legal reasons. And it is often difficult when the lawyers come in. They are trained to see only the legal facts. They are trained that legally it might be better not to say anything. But there is a misunderstanding. If a company shows empathy, this does not mean that it is accountable. It shows that it acknowledges the pain of the people affected. Without this, the rebuilding of trust is not possible. All the three aspects are key to regain the trust of stakeholders and rights holders. Crisis is not finished with words, but with actions. So let us now have a look at the questions. How can companies ensure that grievance mechanisms are not only accessible, but also perceived as credible and safe by rights holders, particularly in high risk or conflict affected areas? A very good question. Mariana, are you going to take that on?
Of course, yes. Indeed, a very good question and a difficult one to answer. The first point that I would highlight is that the process of building credibility and getting people to actually believe and want to bring information to your company, it takes time, like building trust, building credibility, showing the results. This needs some time to take place. So companies should take this in consideration when they're planning the implementation or improvement of their grievances mechanisms. Understand that the performance indicators, the measures, they should consider the fact that it's not going to be one day launching a channel, the next day everyone thinks it's great. I think there's an example from Adidas that has, even much before El Casquet, in the literature is regarded as one of the most responsive, at least, grievance mechanisms. And it's a almost 20-year-old process where they started building on with specific suppliers, and then they made the information more and more transparent about how cases are dealt, what is the result, so you can actually know what you expect when you're accessing the mechanism. So 1, time. 2, transparency about process and expectations. What can people reach when they bring you information? That's really important to align expectations. If you're able to, what kind of remediation you can offer, how long it's going to take, even if it's just, even if the result in the end is not what the rights holder expected, having this clarity about what can happen throughout the way, it really helps into building credibility for the grievance mechanism.
Thank you, Mariana. We have another very interesting question about litigation and strategic litigations, where companies bring their litigation to the jurisdictions where the parent companies are registered, and what this might have as an effect on companies' reputation. Maybe, Leonel, do you want to go ahead with an answer?
Yes, thank you, Paulina. This is actually a very, very interesting question. And there are many aspects to it. I want to cover them as quick as possible. I want to touch on effectiveness, legitimacy, and cultural sensitivity when we're talking about strategic litigation. So of course, in this case, if you have like an international case, you have a parent company in some country. So let's imagine a parent company in an European country and a subsidiary that caused a human rights violation outside of Europe. And then you have a process of a strategic litigation going for the responsibilization of the parent company. So I think that it is important to think first about the effectiveness of that. It really makes sense to go for strategic litigation internationally when you cannot have local effectiveness. So if the courts have no way to provide local effectiveness, or if the company is using a maneuver to distance itself from what happened with the subsidiary and then not answer to the domestic courts of that country. So yes, strategic litigation internationally is very interesting and very useful. But at the same time, what is the effect that is going to cause? Because a reputational cost, reputational damage, as it's in the question, right? That is something that is going to happen as a consequence of that litigation, yes. But is it actually going to go for the reparation of the impacts? Is it actually going to touch the needs of those who had their rights violated? Are we going to focus only on that element of reparation, that is satisfaction, that is the punishment of those who caused the violation, or are we actually from that going to get resources that can be used to pay for compensations and to actually work for the reparation? Very quickly, the other 2 points, legitimacy and cultural sensitivity. There are cases that if you bring the dispute to an international forum, when the decision comes back to the local forum, people have a difficulty feeling that as legitimate. Why is a foreign court deciding on something that happened locally? And also how some of the most delicate cultural elements that are connected with the reparation sometimes is very hard for a foreign judge, even for a local judge, but for a foreign judge is even harder to understand and to deal adequately with those elements. So all this is to say that strategic international litigation is very interesting, very important, but it's not a silver bullet, and it's something that needs to be handled carefully and with the focus on the needs and the rights of the individuals that were impacted and the communities that were impacted.
Thank you, Leonel. We have another very interesting questions on grievance mechanisms. What are ways in which can awareness to grievance mechanisms be created in supply chains, and how can effectiveness be measured practically? Mariana, do you want to go ahead?
Yes, of course. So it will, of course, depend on the characteristics of your supply chain, right? To be able to create awareness about it. What I have been recommended companies is to prioritize supply chains based on a risk-based approach. Of course, having an overall and accessible online form, it's important. Yeah, get to there's a compliance, at least in the German level, there's a compliance requirement there. But in terms of making the work of grievance mechanisms known throughout the supply chains, it's a more of an active effort, which requires prioritization by companies. So that can mean identifying sectors, specific suppliers, but also countries or like geographic regions where you're active, and you start off by engaging with your suppliers, with worker representatives in the supply chain, and then as a trickle-down effect up into to affected communities, if that's something that makes sense to your supply chain, right? But I would definitely say that starting off from where you are, coming down to your direct suppliers, then their suppliers also, but this trickle-down effect of providing training and awareness in prioritized pilot projects. I don't think it makes sense in terms of increasing awareness that just to imagine that you're going to publish something on your website and everyone's going to know about it. It's not really reasonable to expect that. Rather, it makes sense to prioritize than based on risk. There was a second part on how can effectiveness be measured. Again, there are different benchmarks available also online that can be interesting for companies. I think to keep in consideration that you need to consider very important KPI is the level of satisfaction of those that the people that brought the complaint forward with the results. This is definitely one thing to be measured. And you can also look, of course, there's discussions about the number of complaints. If it's increasing, there is an expectation that increases with time, and then ideally the number of complaints will decrease, expecting that the problems will be solved. But also the nature of the complaints. If you keep getting the same complaints over and over again, you can also derive from that, for example, it's not effective, whatever it is, the measure that you're taking. If you get new complaints, different topics, it might be, more related to the dynamic nature of business activity. But yeah, the kinds of complaints you're getting, the level of satisfaction of those that participate in the process, the number of complaints can also be relevant.
Thank you very much, Mariana. Now we come to an end. We had one last question. We will answer that after our webinar, and we will send our communications to you. What did we learn today? We learned that crisis in general can take longer than expected. And it is important, therefore, for companies also to have a look on remedies and remediation, although this is a very complex and dense topic, as we saw today. And although it is difficult, the rebuilding of trust must be at the center, and rebuilding of trust is only possible if the people whose trust you lost are at the center of your actions and your communications. Thank you very much for joining today. We hope to see you soon again. Take care. Bye-bye.